introduction of you all. You just tell me your name. Where are you from? Yes. Yeah. So I'll share my screen and we'll go ahead with our today's topic. Okay. I hope my screen is visible, everyone. If it is not, please let me know.
No, ma'am, it's not visible.
Yeah. Just a second. Okay, just give me 1 second. Okay. I'll share my screen once again. Okay. Again, I'll be sharing. Let me know. Okay. Yeah. Now it's visible, everyone.
Yes, ma'am.
Yes,
Yes,
ma'am.
ma'am.
Yes, ma'am.
Okay. Now, as you can see, the title contractual agreements, a deep dive into the anatomy of a contractual agreements. Okay. So when I will start explaining you all these terminologies or the bullet points which I have written over here, I hope this phones are visible, everyone, right?
Yes, ma'am.
Huh? If it is not visible, let me know. I'll zoom it. Okay. Huh. Now, as you all can see, here are certain things I have mentioned. Okay, the titles, the examples, the essentials, later the tips which are there, later the types which I have written. Later, you can see certain case studies also I have involved. This looks, this may be like you have studied this in your colleges too. Okay, but as we are going to start this course very freshly, so from a application point of view, from a draftsman point of view, we are going to deal with this anatomy. Okay, we are going to deal with all these parts one by one. Okay. Now it's like a short revision for you, or we can say that it's like uh, where you're going to brush up your concepts one more time. Okay. So if you have any view on this, if you have any example regarding to this, you can tell me. Otherwise, even you can ask whatever doubts you have. Okay. Now I feel we should start with this. Okay. Now first we are going to start with the introduction to contractual agreements. ओके इसका मतलब ये है कि यहाँ पे वी आर गोइंग टू सी कितने सारे पार्ट्स आर देयर रिगार्डिंग टू द अग्रीमेंट. ठीक है. इसके पहले आई हैव वन क्वेश्चन टू यू ऑल. ओके, डू वी हैव एनी consolidated form of this contractual agreement? Yes. Do we have any proper form of this contractual agreement?
No,
Yes
ma'am.
or no? No. Okay. Any
No.
another answer? Yes. Okay, you are absolutely right. We don't have any consolidated form of this contractual agreement and even other agreements too. It's not like I'm teaching you contractual agreements, which means we are not going to deal with other agreements. But guys, it's like we don't have any consolidated form, even if we are dealing with another normal civil drafting, normal criminal drafting. Okay, it changes from nature to nature and what type of contract, what type of agreement, what type of draft we are going to make. Okay, so we don't have any consolidated contract agreements or any other contracts or drafts which are there in this field. Okay. Now when we are dealing with this contractual agreements, okay, as I have written a first line, A contractual agreement is legally binding document outlining terms and conditions between two or more parties. Okay. Now, of course, this is a legally binding document. That's why we are saying that this is a agreement or this is a contract. Okay. Now, see, when it comes to conducting any business or when we are engaged in various transactions, right? So contractual agreements are playing their vital role. Okay. Why? Because they are ensuring the clarity, protection, and legal enforceability, right? And as we figured, this is a legally binding document. Okay, this agreement are there, right? So as we all know from a general study, you guys have studied like written contracts are there, verbal agreements are there, implied contracts are there, right? So basically, when we are dealing with this concept of contractual agreement, the basic purpose of this agreement is to establish the rights, the obligations. Okay, next you have the certain types of expectations of each party, those who are involved. Okay, and we are also providing a framework for smooth and mutually beneficial relationship, right? So this is how we are fulfilling certain types of their I can say that relationship which we are deriving from this mutual agreements or contractual agreements. Okay, understood first part, everyone? I hope my speed is fine.
Yes, ma'am.
Yes, ma'am.
Okay. Okay. Now, as we have understood what are this contractual agreement, let's see some examples. ठीक है, as I have written three examples, but I can explain you more. ठीक है. So, first example which I have written, that is employment contract. ठीक है. Now, why we are saying employment contract? Because when the individual accepts a job offer, ठीक है, they typically sign a employment contract that outlining their terms of their employment, including their salary, including their benefits, including their working hours, and any other specific conditions they have agreed upon. Like if their TDS is going to cut from their salary, then how much it will be, that calculation, what will be their in hand salary, what type of work they need to do, what type of employment nature it is. Okay, sometimes when we are making employment contract, we are also making non-disclosure contracts for employment. Okay, sometimes these two are there hand in hand. You need to sign and even if you have a stamp, you can stamp this agreements, employment non-disclosure. Okay, now another example is lease agreement, very famous, leave and license or lease agreements. They are very famous as people are migrating from one city to another city, one country to another country. Okay, why we have this? When we are renting a property, both the landlord and the tenant enter into a lesser or lessee agreement, right? Where they are specifying the terms of tenancy. Like they are writing about the duration, the rent amount, maintenance responsibility, or any other restriction or clauses which are there. Now, why we write all those things here? ताकि इन फ्यूचर में वी शुड नॉट फेस एनी प्रॉब्लम. तो जो क्लॉजेस हमने हमारे अग्रीमेंट में लिखे हैं, हमने हमारे कॉन्ट्रैक्ट में लिखे हैं, अगर उससे कोई ऑब्लिगेट करता है, अगर उसे कोई फॉलो नहीं करता है, तो वी कैन सू दैट पर्सन. एक म्यूचुअल रिलेशनशिप अच्छे से रहे, दैट्स व्हाई वी आर हैविंग दिस अग्रीमेंट और कॉन्ट्रैक्ट्स, right? So even when we are dealing with these agreements, leave and license agreement, यहाँ पे statute, we are saying na statuta personalia, or we can say that the statute which we are dealing with, the statutes given a more importance. Jaise now we all are in India. Okay, we wanted to practice in India, and you are dealing with any civil litigation or any commercial litigation. ठीक है, तो यहाँ पे what certain things are there. Now state to state landlords and rent control acts are different. Now if I wanted to make a rent agreement, if I wanted to make lease agreements, the the laws, the statutes are different. Now, if we are in Maharashtra Rent Control Act will be applicable. Let's say that you are in Kerala, then Kerala Rent Control Act will be applicable. If you are in Karnataka, Karnataka Rent Control Act will be applicable. Uske pehle we were having Bombay Tenants Act, applicable to everyone. But later on, state to state, it changed. Even that different types of no essay varies from one to one. Okay, now coming to the next part, that is your service contracts. Now, by name itself, we can understand it is talking about the services provided. Okay, now why we are saying services provided? So, for services providation, we use contractual agreements to define the scope of their services, right? Their payment terms, the project timelines, or any specific requirement or any deliverables are there or not. Just say, let's say that if you are dealing with international trade contracts, here under this international trade contract, you are having a transactional business with one country and another country. Okay, let's not talk from a law point of view, but from a drafting point of view. What point should be there when they are providing certain types of services, right? Description of the parties are there, what goods they are going to carry, what quality quantity they have, what license permits they have, later which charges and taxes they need to pay, what is the guarantee, what will be the timeline, what will be the general clauses, what will be the force majeure. All these terms we are applying. Okay, so as we are saying, scope of their services. So from this, in future, anything happens, we can lay out the point that time was the essence of this contract or agreement, and you have not performed. So your services are not provided well. So either you can ask for compensation or either you can sue that party. Okay? These are the example of contractual agreement. Understood, everyone?
Yes, ma'am.
Okay, what about others? Only one individual is responding. Others, understood or not?
Yes, ma'am.
Yes,
Good.
ma'am.
Okay, okay. Now coming to the next part.
Ma'am, I have a question. Hello.
Okay, I don't know what happened. I just bumped out from the meeting. Okay, I hope I'm audible.
Yes, ma'am. Ma'am, I have a question.
Okay. Yeah, Aryan, go ahead.
Ma'am, so in
Yes.
service contracts, if there is a breach, then can we sue for specific performance in service only, or is there anywhere else
Yeah.
also we can?
See, it depends upon nature of your contract, Aryan. Okay. Now, as I have given you international trade contract example, here you can sue them on the clauses which you have made in that contract. Okay. If you have any specific performance terminology or any clause you have added or any paragraph if you have added, then you can sue them. It's like, see, when you are dealing with contractual agreements now, it's depend upon what clauses you wanted to add, being a draftsman, being a lawyer. Okay, so you can we don't have any limitation here. Okay.
Okay, ma'am. So
Yeah,
provided
any
that
other
this clause
doubts?
has to be added in it.
Yeah, it needed to be added. Okay, clause needed to be added. Yes, anyone have any doubt?
No.
ठीक है चलो ठीक है. Yes. Now essential elements of contract. Okay, so everyone knows this, right? Offer and acceptance, consideration, intention to create legal relationship, capacity, consent and legality, writing and formalities. You all are aware of this? Yes or no?
Yes, ma'am.
Yes, ma'am.
Yes.
Yes, ma'am.
Yes, ma'am.
Oh,
Yes, ma'am.
oh, great. ठीक है. Now we are going to study this one more time. ठीक है? In short, I'll explain you what are these things and then we'll go ahead. ठीक है. Now, when we all are entering into a contract, we all have seen there are certain things needed to be entertained. Oh, okay. Or when we are entering into this contractual agreement, okay, it is really crucial, or I can say that it's really important to understand these key elements. Okay, why? Because this essential elements or this key elements make contract legally binding, right? Now, this elements are ensuring all the parties involved, they are making them aware of their rights and obligations. Okay, they are providing one type of solid foundation for this agreement. Okay, now in this section or this parts which we are going to learn, okay, of this essential elements of contract, we are giving more importance on how they are significant for providing certain types of practical examples, like what tips you need to follow, what type of examples you need to follow, and even there is one case study I'll discuss with you. Okay, now first is offer and acceptance, your first essential element of a contract, right? So we always say that it should be clear and unambiguous offer made by one party, right? And even which is accepted by another party. So basically, from our Contract Act point of view, an offer is a proposal to enter into a specific agreement, while acceptance is signifying the other party's agreement to the terms proposed. Okay. Now, here we can say that, or for example, for instance, we can say that, let's say that imagine there is a scenario where a company offers to sell a product at a specified price. Okay. And the buyer accepting the offer by agreeing to purchase the product at that price. So this is an offer and acceptance. Right. Now coming to the next part, that is your consideration. Now, consideration refers to something of value that is exchanged between the parties, those who are involved in the contract. Okay? Now, this consideration may be there in different form, like it is there in form of money, in form of goods, in form of services, or even I can say that promises to do or not to do something, right? I hope you agree, Teligal. Now, consideration is something where you are ensuring both the parties are having here a mutual understanding and even the benefit they will gain from the contract. Okay. Now, from a draftsman point of view, when you are dealing with sale, purchase, and trade contract, वहाँ पे we are saying consideration का मतलब होता है exchange of money और price. Price is known as consideration. ठीक है, तो जैसे आपके nature of contract होते हैं, जैसे you are having different types of contract, your consideration form may changes. Okay, so of course when we are in a modernized period, so for us consideration means amount of money received, amount of money paid. Okay, so next is intention to create a legal relationship. Okay, so we are saying for a contract to be valid, there must be an intention from all the parties, those who are involved, to create a legal relation, right? This is a general sense we all know. Okay, so this means that parties acknowledging their agreement is a intention to create their legal relation. Okay, or this parties are acknowledging their agreement is legally binding and is enforceable by the law. Okay, so it is presumed from their side that the relation we are creating for this legal relation except certain relation like family or social agreements. Okay, I'm saying family and social agreements. As you are politely states that their agreement is not legally binding, it may not be considered a valid contract according to our Indian Contract Act. ठीक है. Now when we are dealing with the other contracts जहाँ पे jurisdiction is there of another country. Okay, so for when you're going to deal with that contracts, ठीक है, this is a tip for you. When you're going to do certain type of contracts, you need to check their legal system also, their statutes which are applicable, then decide which clause needed to be added. When we are saying create intention to create a legal relationship, what is legality in their point of view? Okay, I have a question, all of you. Do you know how many legal systems we have? Yes. Do you know how many legal systems we follow? We are dealing with certain laws. Yes. Yes, everyone. Do you know other
Common
legal
law.
systems which are available? Common law system. Very good. Yes. What else?
Customary law, civil law.
Okay. 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 Anything else? Yes. Yes. Anything else? Okay. ठीक है. Now see, when we system, okay, we are having common law countries, ठीक है. Then we are having civil laws, Asian laws, Middle Eastern and African laws. Then we have Latin American laws. Okay, we have African legal system. ठीक है. Here when we are dealing with different type of legals, वहाँ पे ये जो essential elements we have written, इसकी nature changes. Because these key differences are made on their legal tradition which are available. Now you will be like, if I wanted to practice why we are dealing with all these things, know whatever things I'm explaining to you, you should know about this. Okay, being a draft. Am I audible, everyone?
Yes, ma'am.
Okay,
Yes,
I
ma'am.
don't know. Akshay, can you check? 2 times I have been removed from this meeting.
Ma'am, your voice is breaking a lot.
My voice is breaking a lot.
Ma'am,
Oh,
yes, ma'am. I think, ma'am, it's your internet. Probably that is why you are being removed, I guess.
okay, okay. Now it's fine, Aryan?
Yes, ma'am. Much better.
Okay, okay.
Okay,
So
much
I was
better.
discussing, yeah, thank you. Now I was talking about the legal system. Now, when we are a draftsman, okay, being a draftsman, we should know the different legal systems which are available for us. Why? Because certain times we are referring to the foreign judgment. Sometimes we are referring to the cases which we wanted to add in our uh, drafts. ठीक है. उस time पे we should be aware of what type of legal systems which are there and what are their major differences. अभी as I have talked about many legal systems, जैसे common law legal system we have, Asian legal system we have, Islamic legal system we have, African legal system we have, then we have Latin American system, we have Middle Eastern and North African legal system. Now all this have their own I can say their own way of representing their laws. So same it comes to the point of civil laws, as in it comes to the point of more of adding the elements, how they are depicting, how they are giving definition of this. That's why being a draftsman, you should be aware of this legal system. Okay, I'll tell you certain points just may these things are applicable. ठीक है. जैसे some certain times if we are dealing with contractual agreements, sale, purchase and trade contracts, इन तीनों में this legal system के impacts are there. ठीक है. Then when we are dealing with MOU, memorandum of understanding, at that time also you have all these components. Okay, let's say that when you are dealing with non-disclosure agreements, when there are two different countries are involved, at that time also we are writing about the legal system, jurisdictional basis, alternative dispute resolution. Okay, for that purpose, I am saying you should be aware of this. Yes. Pankaj sir, you have anything to ask?
No, ma'am.
Okay. ठीक है. Now, what are main key differences when we are dealing with this? First is their legal traditions. ठीक है. अभी legal tradition, why I am saying legal tradition when we are dealing with the essential का part, कि common law system में we are having a different relation. Civil laws में we are following different procedure. Islamic law is having a different point of view. I am not audible, everyone.
Ma'am, you are.
Okay. Medha, please check your connection, beta. Okay. Second thing is there regarding to the trial procedure you have. Okay. Trial procedure may you have adversarial trial procedure, then you have equistorial trial procedure. Okay. Now, when you are dealing with the drafts, na, at that time also, you need to think about, you need to write about what type of trial procedure you are going to follow. जैसे in India, let's say that कि आप civil procedure follow कर रहे हो. Okay, so civil procedure code में let's say that you wanted to make a plaint, so order 6 rule 2 is applicable. ठीक है, order 7 is there. Now accordingly we are following which rules we need to follow, which fundamentals we need to follow, right? This is how our legal system or legal traditions are. Next is role of the judges, prosecutor and defense attorneys, that also we need to check. Okay, next is there when we are dealing with different type of legal system where they have given emphasis on individual rights which are there, community, social harmony, all these things we need to check. ठीक है. Next we have the cultural and religious influences. Okay, now you will say when we are dealing with the contract, why we are saying cultural and religious influences? Okay, why I'm saying cultural and religious influences, because as we are Indians, okay, India is diversified country. We are having many tradition, we are having different culture, and religious influence is more. Okay, for example, uh, in Delhi, I have seen when I was practicing, there are certain drafts of bail bonds which are still accepted even if they are there in pure Hindi and Urdu format. The olden formats are still acceptable. Okay, even I have seen there are certain litigants, there are certain draftsmen, those who are drafting in Sanskrit, and it is accepted by high courts. It is accepted by lower courts. So language is given more importance when we are dealing with fewer drafts. This is what I wanted to say. And from a legal point of view, it's all there regarding to your rule of law, your separation of power, not more separation of power, but your rule of law, principle of natural justice. All these terminology are more important. See, now, if you know this system or this legal systems are there of mixed nature. Okay, as I am saying, contract drafting, contracts of agreement, ठीक है, we are in mixed systems of laws. जैसे मैंने कहा कि we are having transaction thing, foreign we are getting the different types of law. So we are giving references to their law. We are using law of comity जहाँ पे we are giving importance to different countries' laws. State laws also we are giving importance, right? That's why we should aware there is a need. You should be aware of this. Okay? Understood, everyone?
Excuse me, ma'am.
Yes.
So sorry
Yes,
to interrupt, but
Tanishka.
ma'am, your voice is cracking a
No,
lot.
it's cracking a lot.
Yes, ma'am. In between, it's
Uh,
cracking a lot.
yes, ma'am. Sometimes like there's a big gap between two sentences and it's just
Yes, ma'am, and it's very difficult to understand.
Yes, ma'am. It
Oh,
is
I am so sorry. Now it's fine. Yeah. Now it's fine.
lagging behind.
No, ma'am, it's still cracking.
Maybe what I'll do, just give you 1 minute. I'll log out and do it. Okay. Just wait here.
Okay, ma'am.
Yes. Am I audible, everyone?
No, ma'am. Still cracking.
Yes, students. It's audible. Now it's fine.
Yes, ma'am.
Okay. It's really it's really India maybe because of that I'm facing this issue. I feel that. But from next class I will make sure my connection is good. Okay? I'm so sorry for this and I'll take your move in next class. Okay?
Okay, ma'am.
Okay, ma'am.
Yeah. Yes. Where I have stopped, can you tell me? I'll start from there.
Different laws, like and how
Different.
we should. Yeah.
Yeah. I was talking about different legal systems. Okay. Now, when we all are dealing with different legal systems, just say every legal system is having their own uniqueness. Now, you being a lawyer, you being a draftsman, you should be aware of other legal systems too. ठीक है, let's say that कि in future there is any merger or acquisition is going to happen. So of course maybe there are two foreign entities are there, one Indian company and one foreign company is there. So when you are going to write about their laws and resolution process or problem solving issue inside of your contract, you needed to be aware of those countries laws. ठीक है, for that purpose we need to understand the different legal system. Okay, now when I am saying again and again different legal system, yahan pe most important part is our constitution. Our constitution is being made from taking references of different countries' legal constitution or legal statutes which were applicable, right? And then we have Indian constitution. Agree, everyone? Yes or no?
Yes, ma'am.
Yes.
Right? Yes. So certainly, from a drafting point of view, when we are dealing with certain types of contract, वहाँ पे special provisions are applicable. When we are dealing with more commercial agreements, तो वहाँ पे we are writing certain clauses, ठीक है, which are maybe from a different legal system, or maybe you are going to write about arbitration clauses. तो ये clauses बहुत अलग होते हैं. जो हम हमारी कंट्री में पढ़ते हैं वो same is not applicable. Certain time clauses may be different. Okay, so for that purpose, for from a drafting point of view, आपको वो पढ़ना या आपको उसके बारे में जानकारी होना, it's really important. ठीक है. Now I'll share my screen and I'll start explaining the parts which were left. ठीक है. Now I'm not going to face. Okay. Until my screen gets visible, I'll start explaining you the capacity part. Okay. Now we all know that what is capacity. Basically, capacity is something which is referred to the legal capacity of the parties to enter into that contract, right? Even it is ensuring that all parties, those who are involved, should be sound mind. Okay, they have reached the age of majority and are not under any legal disabilities. General laws, we all know about this. Okay, for example, a minor may lack the capacity to enter into a contract, and or it is making avoidable contract. Okay, so there are certain types of expectations such as contracts for necessities like food, clothing, education, which a minor can be bound by. Depends upon the nature, we are deciding the capacity. Okay, next part is there regarding to the consent and legality. Okay, now consent is something which we can call as the critical element of your contract. I do feel, and even many of the ideologists or draftsmen have said that. Okay, जैसे in contractual drafting or Indian Contract Act में Moga is one ideologist, or Moga is one of the reference has been given कि Moga writes more about this contractual agreements, its Indian agreements. Even he has stated that कि consent is a critical element. Why? Because when we are dealing with certain types of contract, we are ensuring that all the parties are agreeing to their terms willingly, without any undue influence, without any coercion, or without any misrepresentation. If the consent is obtained through the fraud, mistake, duress, so generally we call, or naturally that contract becomes avoidable. ठीक है. Additionally to this points, a contract must be a lawful to be enforceable. Okay, or we can say that it must be a lawful to be enforceable. It cannot involve illegal activities, or it should not go against the public policies. Right? Generally, we all have seen in our Indian Contract Act too. Okay, now coming to the next part, a last part, that is your writing formalities. Now, many of the contracts can be oral. There are certain agreements which must be there in the writing, or when they are in writing, we are saying they are enforceable. Now, this includes contracts involving the real estate, marriage, sales of goods over certain value, or agreements those cannot be performed within 1 year. Okay, so it is advisable from our lawyers, and it is advisable from drafting point of view also. Key this is advisable that this contracts needed to be written contracts, even if not legally required, as they provide a clear record of agreed upon the terms, agreed upon the terminologies or the policies which you guys have made or mutually decide. Why? Because it helps to avoid misunderstanding in future, because we don't know what scope we will be having later. ठीक है. Now understanding all of these key elements of contract, it's really vital for everyone those who wanted to enter into this contract. ठीक है. And by ensuring that this elements we present certain things or we present a solid foundation for their agreement. And we all are keeping all these points because we don't want it to likelihood or to likely have certain types of dispute in future. Okay? And even we are ensuring here about the enforceability which we have. For that, we all are having this essential elements of contract. Understood, everyone? Yes?
Yes, ma'am.
Understood,
Yes,
ma'am.
ma'am.
Great. Great. Yeah, someone said you have a doubt? Okay. Now, the things which you can see later, the tips for creating effective contractual agreement, then types of contracts, and one case study, and importance of clear and concise language. This we are going to cover in tomorrow's class. Okay? As you are having a connecting factor in tomorrow's session, as it is there in your brochure also, in your syllabus also. So first we started today with the contract and even we have completed the elements. So tomorrow we are going to see with other elements and tips. That is your important section in contractual law with other important key features. Okay, and tricks which we have. Okay. So if you wanted to read, if you wanted to have a discussion, so please read this and then we can go ahead. Okay.
Could you share the PPT with us?
Yeah, I'll share this document with you. Okay.
Oh, thank you.
Yeah. So I hope you all have understood, everyone. Yes.
Yes, ma'am.